You gonna scare me?
Okay, let her go, Hayley. Come on. Come on, Hayley. We gotta go. Come on.
Okay,
come on.
Two teen girls out in Illinois are accused of beating up other people, including an alleged assault that was maybe captured on video. This is a wild case with wild allegations that we're going to get into right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Two Illinois 18-year-olds could face months behind bars after being charged with what's being called mob action. We'll talk about the legal definition of that in a minute, but it appears that not only these allegations, but some of this might have been recorded and maybe shared. April 23rd, Hayley Ditzler and Olivia Brown were booked into the jail in Madison County, Illinois, which is in the southeast part of the state near St. Louis. And the teens are accused of targeting a local woman, luring her into a wooded area and attacking her. And members of the community say that's not the only person they've allegedly beaten up. Talk about this, I want to bring in criminal defense attorney Andrew Baldwin. Andrew, so good to see you. Thanks for taking the time to come back here on Sidebar.
Good to see you again, Jesse.
So, Andrew, according to the charging information, Ditzler and Brown, acting together, allegedly dragged the victim into the woods, repeatedly punched and kicked her in the face, mouth, stomach, arms, legs. This is if true, a full-blown assault on her entire body. Certainly seems like the allegation would be it's premeditated. What's just your initial reaction to an alleged crime like this?
Well, as a defense lawyer, when you get somebody walking into your office that says, my daughter's been accused of this crime, you go through your thoughts as a defense lawyer. First and foremost, they're presumed innocent, and you're hoping that there's going to be some lack of evidence or some evidence that's helpful for the client. Then you also flip on your human being side, you're a parent, and you start to think, my God, what's going on here if this really happened. And so those things kind of conflict at times. And so just as a defense lawyer, if that's what you're asking, you really have to kind of push that down, right. Those feelings as a parent. And you got to say, let's look at the elements of the crime. Can we defeat this case?
So what might complicate or what makes this a little bit different now is that while Ditzler and Brown, they only face charges right now in connection with that attack, that alleged attack, another teen has apparently come forward to say that she was also attacked by Ditzler and Brown in a very similar manner. Evie Behrens apparently posted videos of her alleged assault on social media after it appeared footage of the attack was shared on Snapchat by Hayley Ditzler. In one of the videos, one of the suspects apparently places their phone on the ground, pointed it toward a basketball court. It's dark out there, but you can see the outline of someone seemingly dragging someone else into the frame. And you can hear as at least one of the suspects starts apparently assaulting Behrens. And based on the footage that she shared, Behrens doesn't appear to fight back and can be heard saying things like, "Okay, I'm sorry guys, please stop." And it appears that Behrens refers to both Hayley and Olivia by anime. And after landing a few blows, the suspect, who we believe to be Olivia Brown, picks up the phone while it's still recording and appears to think the fight is over. But a person referred to in the video as Hayley continues to cuss at Behrens, and you can hear more blows landing. Behrens' screams get louder and more intense, and Brown seems more and more concerned that someone might come to Behrens' aid.
No, Hayley, we got it. We got it.
I can't. Come on, fight me.
No, we did it.
Dude, you guys jumped me. You fight one of us one-on-one. Or it's not done. Oh. You fight one of us one-on-one, I will let you get your shoe on because I'm not behind me.
Shorty's gonna we got it.
No, one-on-one.
Now go. Go. I'm telling her go.
I can't see. I can't. Olivia or me. I can't.
You can see me though. You can see me. Olivia, stop. No, you stop.
So the girl believed to be Olivia repeatedly tries to get Hayley to leave with her, saying, "We made her scream, it's over." And as the two teens finally walked away, they could be heard telling Behrens, or allegedly telling Behrens, to never disrespect either of them ever again. Okay, Andrew, first let's talk about if this video is what it purports to be. can that be used as evidence in the other criminal case?
That's a great question, Jesse. And in most situations, the answer would be no. The rule of evidence that usually prevails is 404B, and it does not allow a prosecutor to admit evidence of a prior bad act. However, under 404B, there are permitted uses when you can bring in that evidence. And one of those permitted uses is for MO, or modus operandi, when there is kind of a signature of the way that they do things. And that could fit the bill here. And that would be pretty devastating on the case with Miss Ditzler and Miss Brown if that were allowed to come into evidence.
And so, in other words, to establish a pattern of attack. But I guess the question would be, and just to be clear, you don't have to be charged with that evidence to come in. They don't have to be convicted or charged. It could just be, this Miss Barron's taking the stand, saying this happened, playing the video.
Yeah, absolutely. It would be highly contentious in the courtroom. In a pretrial motion, you'd probably bring her in there, and the judge would have to. It'd be really factually based. Is this so similar? Is this such a pattern that we can rely on it to not do what it's really intended to do, and that is to show that these girls are acting and that Miss Brown and Miss Ditzler did exactly what they did previously, and that's a forbidden inference that's not allowed. But 404B will allow it if a judge allows it.
By the way, off topic, but another serious issue I want to talk about with you real quick: debt. Debt doesn't just show up one day. It builds little by little. Credit cards, car loans, medical bills, and suddenly you're juggling payments. You're feeling stuck. Here's the good news. We got American Financing as our sponsor. So they help homeowners like you every day. They use your home's equity and they roll that high interest debt into one simple, affordable payment. They're saving homeowners an average of $800 a month. No judgment, no pressure, just real solutions that put you back in control. It starts with one call. Only takes 10 minutes to get started. And there are no upfront fees, so it costs you nothing to find out how much you can save. And if you start today, you may be able to delay your next 2 mortgage payments. American Financing salary-based consultants are ready to listen, and they're ready to help. Take back your peace of mind with American Financing. Call American Financing today at 866-891-2821. That's 866-891-2821, or go to americanfinancing.net/sidebar. At the time of this recording, they haven't been charged with respect to Barron's, my understanding is. Why do you think that might be?
It's hard to know. In today's world, there's crazy things that happen on these, especially with young people, and you want to make sure that this wasn't contrived, perhaps. Like, is this everybody involved in a show? I know that sounds crazy, that maybe Ms. Barron's is part of a crew of people that are trying to get likes on a TikTok page or something like that. Maybe that's what it is. I mean, prosecutors have to be very careful nowadays before they file anything involving video online, especially young people, because they have a tendency of doing things that we adults would not expect.
Just what's your reaction to that video? Because the video evidence is so important. I mean, it's so compelling for a jury. Let's say they are charged in connection with that attack, that alleged attack. How do you argue against that? What do you say about a video like that?
Well, life, as I often say, is crazy in other people's worlds. And like I said before, you don't know exactly what was going on contextually behind the scenes. Were these 3 girls involved with one? It doesn't seem that way. It seems like it's legit. So as a defense lawyer, you're trying to find out, is there more to the story here? So you got some early decisions to make. Am I going to accept it for what it is and go to the prosecutor and say, hey, let's work out a deal before this kind of gets out of control, or are you going to fight it? Normally, I like to let the evidence come to me first before I start making decisions like that. I want to find out what they have and what they don't have. And I really don't want to find out from my client necessarily early on, like, tell me what happened. I want to wait until the evidence comes to me. But in a case like this, when there's going to be some publicity and the evidence is seemingly really awful video evidence, maybe you find out more quickly from your client, did this really happen? Because if it did, I need to do some damage control. And we need to get in there before, Ditzler, if I'm representing Ditzler, then I want the better deal first. And if I'm representing Brown, I want the better deal first. Let's get that best deal first.
Now, Behrens also shared a short clip of herself in her car after the alleged attack, showing a cut on her knee, makeup running down her face from crying. Take a look.
Bro, I don't know what to do, bro. Crazy, bro. My whole head is like pounding.
Now, Behrens told First Alert 4 in St. Louis that Ditzler and Brown, they have perpetrated multiple attacks in Madison and St. Clair counties, and that while they were all once friends, she distanced herself from the two after they started allegedly targeting people. Now, Andrew, generally speaking, are we seeing a lot of youth violence cases like these allegations? Have you been covering them? Are you seeing an uptick in them at all?
Big time. I mean, it's I've done this for 30 plus years now, and I've not ever seen the amount of youth on youth violence. Maybe it was always going on and they just didn't videotape it and throw it on YouTube or whatever, and therefore it has always gone on. But that's not what I think. I think it's kind of driven by social media because, like, again, even this victim, if she is a victim, Behrens, she goes on television or she's in her car and you just got beat up. Why are you doing that? It's a weird, there's kind of a weird sickness going on with the youth.
Well, you could say she's trying to bring awareness to this. I mean, she spoke with Five on Your Side, telling the outlet that she'd been hanging out with friends when she saw a bunch of boys in ski masks sneaking up to her car. She says she saw Brown and Ditzler, drove away, and the next day, she claims her former friends texted her, saying they wanted to apologize, lured her out to the spot where the attack allegedly happened. So it seems to me the counter-argument to that would be, Andrew, she's trying to bring awareness to what happened or allegedly happened to her.
Well, I think going to news media is one thing, but going on your Facebook page and posting about it is something different. I mean, now we're not talking about the law; we're just talking about society. I just find it to be an odd thing to do, and it makes her less appealing as a victim as well. And maybe as a defense lawyer, I could glom onto that a little bit somehow.
Now, Behrens' mother, Lara McCord, told First Alert 4, quote, she was scraped up like road rash on her leg and her back. She had bruises on her back. She had a swollen eye. It was bloodshot, a bruise on her other. Her lip was busted a little, but the most concerning thing is that she had a concussion. So I imagine, Andrew, is that a medical conclusion from medical reports? It's important for this to be documented, correct?
Yeah, of course. I mean, later on, whether it's an element of the crime might require a definition that includes concussion or something like that. So or broken bones or scrapes or pain. So you definitely want to get to a hospital and get that. If you're a prosecutor, you want to get those records.
Now, I want to talk about what they're facing. So with that separate attack regarding that woman, that alleged attack, Brown and Ditzler, they face a charge of mob action. So according to the Illinois criminal statute, it says a person commits mob action when he or she engages in the knowing or reckless use of force or violence disturbing the public peace by two or more persons acting together and without authority of law. And the teens could face between 1 and 3 years in prison if they're convicted of it. That's our understanding. I've never seen a charge like that, mob action.
Yeah, mob action. When I saw that, it's kind of a funny title for a crime. And it's not, I thought, well, maybe this is social media driven legislation that caused that, but it's been around since at least since the 1990s. I was going through some of the case law that details, what it is and what it isn't, according to the Court of Appeals in Illinois. And it's been around a while. And, there's been some overturned convictions of mob action because there's a specific intent of why that legislation exists.
And I imagine one of the areas that a defense attorney could hone in on is acting together in concert.
Yeah.
And I wonder that could be an area where you say, well, wait a minute, I wasn't on board with that. I just was watching. I mean, right? Talk to me about what that issue could be.
Yeah, you nailed it. I mean, one of the cases that I read talked about, it was two groups of people, two guys were in a fight, and then they each had a buddy standing next to them, and then those two guys got in a fight over the other two fighting. And so it was two groups of people. It seemingly met the definition under the statute, but then in the end, the Court of Appeal, there was a conviction, and then the Court of Appeal said, no, that's two different things. They were not acting in concert on the same thing. So with Miss Ditzler and Miss Brown, I mean, it could be fact intensive. It seems kind of self-explanatory. These girls worked in concert together, lured her into the woods. But what happens if one is arguing about, you said this about, you dissed my boyfriend, and the other one is like, well, in third grade, you did this to me, and they're arguing about two different things. Can you argue that that's not acting in concert? They're actually arguing about two different things. I know it seems, for non-lawyers, they may think, well, that's just a silly argument, but those are the types of things that might win the day, might get the charges even dismissed.
If they are convicted of this, what do you imagine the punishment could be?
Well, like you said, I 1 to 3 years is what they're facing. They're 18 years old. I looked at their mugshot, and if I were a prosecutor, I would take that mugshot, and they seemed, you don't want to read too much into a mugshot, but I'm sitting here looking at it. They seem very they seem like they just don't care. They're smiling, they're smirking, you can almost read into it like, oh, we're going to get some good clicks on this or something. I mean, and if I were a judge and I saw those mugshots, and if the girl's demeanor is consistent with that at sentencing, I got to tell you, as a judge, I might say this is an important time in their life. They're 18 years old. They're doing this other places, perhaps. They need to spend a little time in jail and really think this through, and then they need to get some counseling and things like that. When they're 18, and they don't have a prior criminal history. If that is the case, it's easy to think, let's slap them on the wrist and let them go on their way, maybe with some counseling. But I don't know if that is going to help them as human beings on their the road that they travel.
Now, Barron's told First Alert 4 they don't care, and I feel like they would do it again if they hadn't gotten caught. They would still be out here doing it and still be trying to find me. And she says she's now filed a restraining order against Brown and Ditzler. We checked Madison County court records and found that there are emergency no contact orders in place with a hearing scheduled for later this month. I mean, Andrew, something to point out about this is we did reach out to Barron's and her mom, Lara McCord. They declined to speak with us now that the investigation's ongoing, but McCord did post an update on Facebook saying, hello, everyone. I am Evie Barron's mom. I'm asking everyone to please stop threatening Hayley Ditzler's and Olivia Brown's family. They are getting death threats. Please just let the justice system handle this. Thank you, everyone. And look, you certainly don't want to see reciprocal violence or some sort of revenge attack or anything like that. We've seen in the past that sometimes people can have serious bravado behind a screen that might get them in trouble in real life, but that's a serious problem. And it's the idea of the no contact order. Let's first start there. What's the purpose of it? How effective is it? And also, do you see the concern about posting so much on this on social media?
Yeah, the protective order, some people say it's only as good as as a piece of paper. You can walk right through that protective order if you really want to. I think most of the time it does its job. The purpose of it, of course, is to prevent Ditzler and Brown from going after the victim again, the alleged victim again. And because if they do, they face new consequences. First of all, they might revoke their bond and they just stay in jail during the entirety of the case. So I think it's really the only thing that you can do. And as far as the other thing you're talking about there, Jesse, which is I see this all the time where the victim's family does come out and say, hey, take it easy on the other side, which is a nice thing societally to see that the mom is doing that. I think it's a really terrific way to operate. So I appreciate that. Just even as a defense lawyer, I can say that's a great thing to do, Mom. Way to go.
And speaking of this, by the way, so Barron's herself apparently posted about her own past conduct a few days after the alleged attack, saying in part, everyone I have fought in my life, I have made up with and are my friends now. For people to blame me for this is so hurtful. I have got with wrong crowds before and been in bad situations. Everyone makes mistakes. I would never hurt someone how these girls hurt me. I would never wish this on anyone. And she later posted an update writing, my fight videos are going to come out, of course. I've never hurt someone as bad as these girls hurt people. Again, I am friends with the girls I fought. People are going to come at me and make up false things. I really hate it. I am not the same as Hayley and Olivia. I've had a fight phase, but I've never been sick like them. I would never hurt someone like them. This hurts my mental health, and I cannot take it. Andrew, what do you make of that?
Wow. I'm salivating as a defense lawyer right now, listening to that, because now the game changes a little bit. If what she's doing is preemptively telling the world, like, hey, there's going to be some fight videos of where I've been the aggressor and I've beat up some people. Now you get into self-defense. Now you get into other possible defenses out there. And now the 404B that I talked about earlier may turn the tables on Barron's, where it's like,
Meaning if she testifies, this could come against her.
Oh, absolutely. I mean, I would be absolutely fighting for that, especially if they are charged with, Ditzler and Brown are charged with crimes against her. That's absolutely going to be grounds for fighting over whether those videos come in. And now you're talking about an entirely different ballgame as a defense lawyer. You don't fear the video as much because there's other video that they have to fear. And then that becomes a tool for plea negotiations.
By the way, in a motion that was filed with the court, prosecutors requested special bail conditions to prevent the suspects from having any contact with the other girl that they allegedly attacked. The motion states, the defendant has previously threatened or perpetrated physical abuse toward the victim in this matter. On information and belief, the defendant presents a continued threat to the victim, and the defendant may harm, harass, or interfere with the personal liberty of the victim during the pendency of this action. Now, the court records indicate that the judge signed off on standard and additional pretrial release rules, but it's unclear if the defendants were required to post any sort of cash bond before they were released. Andrew, you have thoughts on this?
Well, it's probably more talking about a protective order of the court's own choosing versus a separate protective order in a separate action. The judge, as a condition of bond, can say, hey, you cannot be hanging around those girls. You can't talk about them on social media. Your friends can't go harass those girls. If you do any of that stuff, you're going back to jail. That's your condition of bond. And that is probably what that's being talked about. They have a right to a bond, a constitutional right to a bond. And but if they are released and they get in contact, if the judge says you cannot get in contact, that means they'll get thrown right back in jail.
Yeah. By the way, they have both the Ditzler and Brown, they have a preliminary hearing on May 16th. What can we expect from a preliminary hearing?
Usually those are a nothing burger. There's not a whole lot going on. It's, hey, when are we going to get our trial date? Is there anything I as a judge can do for you to expedite discovery, things like that? It might be the judge taking an opportunity to remind Ditzler and Brown that they are not allowed to have any communication with the alleged victim and that kind of thing. So it's a lot of housekeeping.
Oh, I thought it was, they present enough evidence to move forward. It's almost like, what prosecution, what do you have? Is there probable cause? Would I be right about that?
Well, this is where, I'm sorry to interrupt, Jesse. Yeah,
yep.
You might be right on that. I'm not in Illinois. I'm next door in Indiana.
Sure.
In Indiana, that's what a pretrial hearing is. In Illinois,
okay.
that might be something a little bit more adventurous than what we do in Indiana.
Well, in Indiana, are there preliminary hearings where the prosecution has to put forward evidence to establish probable cause? Because I've spoken to defense attorneys before who say, we kind of like it, kind of gives us a view about what the prosecution has, where they're going. There are other defendants who waive a preliminary hearing. Talk to us about that.
Yeah, in Indiana, we charge by information, meaning it's a piece of paper sworn by the prosecution that all these facts are true, as detailed by the police officer. And then a judge looks at it, and if it meets the definition, or the elements are met through the information, the probable cause affidavit, then the judge signs off on it. In Ohio, where I went to law school, it's different. It's more like what you're talking about, where there's a hearing and they bring in law enforcement, and that's really, in Ohio, that's really your only opportunity to cross-examine the law enforcement officer, because they're not going to talk to you afterwards in Ohio. In Indiana, we have depositions that we can conduct. And we're one of the few states that does that, but they don't do that in Ohio. I don't think they do that in Illinois. Yeah. So yeah, if you're a defense lawyer, I'm guessing you never want to waive an initial hearing on a case like this, especially. You want to get as much information on the record so that later on at trial, if there is a trial, you can impeach the witness with their prior testimony.
Absolutely, absolutely, and as they should. That's a great mechanism to cast doubt on the prosecution's case. Andrew Baldwin, great seeing you. Thank you so much for taking the time to talk about the case.
Thank you, Jesse.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.